Welcome to This Week in Family Law, the go-to podcast for busy Australian family lawyers who want to stay updated without the overwhelm. I'm Jenna Downey and my co-host today is Dina Palethorpe. Dina, how was your weekend?
It was very good, thanks. I binged watched this show called The Mysterious Case of Natalia Grace. I won't say too much in case you want to watch it, but it's about this little orphan girl. She's 6 when she's adopted by this couple in the States, and then things start going wrong very quickly. They think she's, 15 years older than what she says she is. She has dwarfism, so it's not, quite as clear how old she is. And I won't spoil anything else, but it's a crazy ride.
It sounds like it would have been very interesting to watch. Let's get into this week's update. What's up, Dina?
Yeah, so I think in our last podcast together, which was episode 12, I referred to the inquiry into the link between domestic, family and sexual violence and suicide. So there was a hearing in Sydney and the transcript of that has now been released, and there were some really interesting statistics that came out of that and some interesting comments that were made. So I thought it would be interesting to share it with you. So somewhere between 28 and 56% of completed female suicide cases actually involve domestic, family and sexual violence. Family court proceedings were specifically identified as a suicide risk escalator. The Warringah Baya, the Aboriginal Women's Legal Centre, they gave evidence that threats of suicide are often used as a tool of coercive control, which I thought was really interesting. And there was a term during the hearing that was used that I couldn't stop thinking about, sexually transmitted tax debts. So it was Professor K.S. Kumar from the UNSW Tax Clinic, and she used that term to describe perpetrators accumulating tax debts in their partner's name. And really interestingly, the clinic had had 17 clients referred to them directly from Lifeline, not from the legal aid office, but from a suicide hotline. So it really just goes to show how linked these concepts are.
I've certainly heard of a few examples where, in practice, where there has been tax debt accrued and the other person didn't know about it.
Yeah, and it can be such a big deal, like life-changing.
Oh, huge amounts of money. Yeah.
So the next update I have is about the Children's Online Privacy Code. I'm not sure if you've heard about this, but the Office of the Australian Information Commissioner has been tasked with putting together a Children's Online Privacy Code. So an exposure draft of the code has been released, and that consultation process is now open, and it will be open until the 5th of June. So anyone that's interested in making a submission, now's the time. Or even if you're interested in looking at some of the submissions that have been made about it. But in short, that code is intended to regulate what platforms can do with children's data, how they collect it, how they store it, how they delete it, and what settings they must apply by default. So really interesting when we're dealing with parenting matters where we've got sort of children of an age who are, going online and it's, parents are wanting to know what they're doing.
Yes, yeah. I feel like it's always a concern for parents, isn't it?
Yes.
And we can provide a link to that in the show notes.
Yeah. I guess so. One of the most important things coming out of it is that platforms must have privacy protective settings switched on by default. They can't target ads at children because they have to collect their data to do that. So it's some really important safety protections for children.
Yes. And I know from using social media myself that that's certainly an issue even with adults.
Yes.
The targeted ads and information that get fed to us all the time.
Yeah, it's pretty scary. And then my final update is I was reading an article on Lawyers Weekly entitled Perfection is the Enemy of Progress. And this really I see myself in this article, but a senior managing partner of Travis Schultz and Partners, Travis Schultz, argues that perfectionism in the legal profession has become a significant barrier to productivity, well-being and progress. He draws a distinction between simply having high standards for your work and toxic perfectionism. And I'm sure a lot of the people listening probably see a bit of themselves in this. I know I do. And it's, I remember, I think that last 10% when you're working on a piece of work is often the most expensive because you're spending the longest time in, finalising it, perfecting it.
I can certainly relate to it as well. And it can be exhausting, can't it?
Yeah.
In an already quite complex job, and the work and the drafting, the reading, there's a lot to it. So to have to feel like you have to get to that level of perfectionism, it can be difficult. And as you were saying, I think a lot of other listeners would relate to, particularly if they are lawyers, because we are a certain personality type too.
Yes. And I think what he goes on to say is that we're prioritising quality over productivity. And I mean that there is a line that we have to draw at some points.
Yes.
But, I would find that I would still, in my head, I would spend that time doing the final review, looking for typos. I'd still miss things and then I would beat myself up about it.
Yeah.
And it's just, it's this vicious cycle.
Yeah. You just got to get it done to a level of satisfaction and be happy with that.
Yeah.
Thank you, Dina. And that's what's up for this week. For Law in Motion this week, Dina is going to help lawyers understand family violence and in particular financial control and economic abuse. Dina.
Yeah, thanks, Jenna. So it really is a hidden form of family violence and one that can act as a powerful barrier to leaving a relationship and establishing long-term independence. So as we all know, the Family Law Act was amended in 2025 to expressly recognise financial and economic abuse as a form of family violence. And the changes now mean that it's relevant at the property settlement stage, even if we don't have parenting proceedings on foot. So nearly a year on from those amendments commencing in June 2025, I think it's a useful moment to take a look at what economic abuse looks like in real terms, because it's likely that we're still, as a profession, under-recognising it, partly because we don't always recognise the full gamut of what those behaviours look like, and partly because it's quite difficult to plead. It's very subjective.
And even though we've come a long way in terms of our understanding of family violence, you're right, people probably don't appreciate all the nuances that do make up what could exist as family violence.
Yeah. And as I said, it's very subjective, And so that's why I wanted to take a look at this topic and then look at the harder task of what best practice looks like when you're actually acting for the alleged perpetrator of the family violence. So as we all know, in 2025, the definition of family violence was expanded. Economic abuse is now expressly framed as a form of family violence, whereas it used to live inside the broader financial autonomy example. So I think it's easy to talk about these high-minded principles, forcibly controlling money, but we need to look at what this looks like actually in practice. So it might be a case where one party has full control over the family finances. They control the joint account and they simply transfer a stipend to the other party. Or it might be the case where one party sabotages the other party trying to earn an income, whether this is, pressuring them to stop working or making it practically difficult for them to not work, like refusing to pay for childcare, for example. Or the case of when there are coerced loans or debts, one party, whether with the knowledge or without the knowledge of the other party, takes out loans and tax debts in that party's name. Or the case where there is the creation of loans post-separation. There are these loans that the one party didn't realise existed and, you're in the midst of family law proceedings and they get put on the balance sheet. So I think it's important to sort of try to pick out this behaviour. The hard question is when you're new to a matter, how do you spot it? You have to ask the questions directly. Who controls the money in the relationship? Have you ever had to ask for permission to spend money? Do you know what you own and what you owe? Try to pull the documents early. Get your client's financial disclosure as early as possible. But also be mindful of the language. If one party is saying, he gives me or she lets me do this or I'm not allowed to do this, those are red flags. Last year, Fiona Kirkman and Joplin Higgins did a webinar for us about family violence and specifically looking at when you're acting for the perpetrator of the family violence. Joplin recognised 4 typologies of a perpetrator of family violence. So it might be that they're entitle-based, someone who thinks that they should be the one making the decisions about the money. This might be because of how they were raised, because they're the higher income earner, or simply because they see themselves as the smarter person in the relationship. The harm in this case comes from the years of making small decisions adding up, and it's not from just any one incident. You then have the survival-based perpetrator, someone whose own background, childhood, an earlier abusive relationship or formative trauma has left them feeling that controlling money is the only way to feel safe. They can be defensive, quick to read questions as an attack. You then have the situational perpetrator, someone whose behaviour came out of a specific bad period, a business failing, a death in the family. They're probably the easiest to work with and the most amenable to change. And then the final one, the sadistic-based perpetrator. They're the highest risk of the four. And their behaviour includes conduct that deliberately wants to hurt the other person or taking enjoyment in the other person's distress. Behaviour change programs don't typically tend to make any difference with those perpetrators. So I think it sounds basic to say, but disclosure is such an important thing in these matters. You as a solicitor, your role, from day one, run it cleanly. The duty of full and frank disclosure is, it's not optional anymore. There have been changes to the Act to sort of refocus parties on that. Also, don't drip feed financial disclosure. Tactical late disclosure reads as concealment, and the courts really become more attuned to that. It can also expose your firm to costs orders or professional conduct complaints and damage your credibility in the profession. Also, document your advice. If you're ever unsure, get advice from counsel. I remember negotiating a binding financial agreement, and my client did not want to disclose some assets that she had. And so I ultimately ended up ceasing to act on that file, but we had talked about getting advice from senior counsel in that matter. So it's scary because it can happen.
Yeah, I have an example as well of a client who they didn't want to disclose certain information, and when you know about it as their lawyer as well, you've got to advise them to disclose that information.
It puts you in such a difficult position.
It does, yeah.
And I guess another thing as the solicitor that you need to be doing is you need to make sure that your client understands the post-June 2025 landscape, and that they're aware that the Act now expressly recognises economic abuse as a form of family violence, and that this can have a flow-on effect then in terms of a property settlement. The other thing is, don't become part of the problem. The legal process itself can become a vehicle for ongoing financial abuse, and Part 11B of the Act gives the court tools to intervene in those cases. The court can dismiss proceedings if it thinks they have no merit, that to continue them would cause harm to a party or a child. Interestingly, about that point, the court can go on to find that there is merit in the case and still go on to make that order that the harm would outweigh the benefit of the continuation of the proceedings, and that the proceedings have been brought as an abuse of process or for a wrongful purpose. So watch out for these types of applications, repeat interim applications on urgent issues timed to coincide with the other party's financial vulnerability, for example, just before a mortgage payment or after they've depleted their savings. Applications to vary or set aside financial orders based on alleged financial changes that aren't supported by the evidence. Repeated disclosure requests that goes beyond what the case needs. Subpoenas to the other party's employer or business clients. Repeat child support variation applications, and drawing out responses to applications for things like urgent spousal maintenance. So all of these vehicles are a way for the continuation of that family violence.
Yeah, so it's for the lawyers to call out that type of behaviour.
Yeah.
Draw it to the court's attention if they're not aware, and hope that that's addressed.
And it's important to have those hard conversations with your client. Test them. is that application really necessary? Is there something else we can do? We have professional boundaries that we have to sort of abide by that are really important. Things like, don't engage in denigration of the other side. I remember being a very junior lawyer and I had a client. Well, I was assisting a senior lawyer with a client. I was just executing an affidavit with the client. And the client started going on about the solicitor on the other side, calling her things like she's a pig, she's a dog. And, I'm sitting there and I'm like, oh, I don't know what to do. And I think it's important that we train our junior staff so that they know how to deal with those situations, how to put an end to that behaviour, because that's not acceptable. You're not the client's therapist. You're there to give them legal advice.
And perhaps it is referring them to a therapist, for instance, so then they can, if they come to you then for advice, they are probably in a better headspace to receive that advice, and they're not going to want to do certain things that is perpetrating a type of violence or abuse.
Yeah, they can ventilate those feelings in a more appropriate venue than your office.
Yes, yes.
I guess as I said before, don't be afraid to have those hard conversations with the client, whether it's about the merit of their case or whether it's recommending they attend, a behaviour change program. Also, another really important thing is don't write in unnecessary correspondence. If a letter or email does not directly assist your client's case theory, don't send it. Volume is not advocacy. And tactical correspondence, that is designed to pressure, harass or wear down the other side rather than advance the real issues in the matter. That's the kind of conduct that increasingly attracts costs orders and disciplinary attention. So I think there are some red lines of when you should stop acting. And there are 4 categories of conduct that should sort of trigger your consideration of whether you can continue to act for this client. Firstly, if they give you instructions to mislead the court or another practitioner, I feel like that's a one-strike offence. As soon as you do that, I can't continue acting for you. It's a really serious one.
Yeah, agreed.
If there is a persistent refusal to give full and frank disclosure, I think this is different from, a single oversight of, missing giving something. But if there's a pattern of strategic non-disclosure, you can't overlook that. Important in those cases to give written advice so that you can always rely on that when you come to terminate the retainer. If there's continued contact, intimidation or financial pressure on the other party in breach of orders or undertakings, a single breach may be brought back into compliance with advice, but if there's a pattern or if a first breach involves intimidation, financial pressure or fresh family violence, it's important to stop acting in those circumstances. And finally, if there's an insistence on running unmeritorious applications for tactical reasons after you've given them written advice not to.
Yeah. They're important things to remember as well. I feel like when we do a lot of legal education, it is often how to deal with clients who come in and they're the victims of violence and trying to help them through the process. But when you have the perpetrator of violence, there's probably not enough education for lawyers to help them manage and deal with those clients, see the red flags, call out the behaviour. So I feel like what you've shared is really important. For Case Note Corner this week, we're keeping to the theme of family violence, and Dina's going to talk to us about the case of Malunus, number 6, which is a 2025 decision.
Yeah, this I thought was a really interesting case because it's one of the first developed first instant treatment of the new economic abuse provisions inserted by the 2024 amendments. And there's a substantial discussion on what it actually means to coerce or control under Section 4AB. So the case involved both parenting and financial proceedings. There were 2 children. They were aged 5 and 3 at the time proceedings were commenced, and they were 11 and 8 at the time of the final hearing, or the second final hearing before Altebelly J.
That's a very long period of time.
I won't go into the whole history of the matter. But so at the final hearing before Altebelly J, and as I said, that was the second final hearing of the matter. The mother sought orders for sole parental responsibility of the children, leave to relocate to a different city, for the children to spend time with the father each alternate weekend from Friday to Sunday. And she actually sought a vexatious proceedings order under Section 102 QB2, prohibiting the father from filing further contraventions without leave of the court. The father, for his part, sought effectively the continuation of the status quo. That was for mum to remain living in the same city and for equal time and equal shared parental responsibility. So the discussion of family violence and in particular coercive and controlling behaviour is the heart of the judgment. As we all know, after the 2024 amendments, Part 7 of the Act now operates with a focus on the safety of children and their carers rather than the protection from harm. Section 4AB1 defines family violence as violent, threatening or other behaviour that coerces or controls a member of the person's family or causes them to be fearful. And that now expressly includes economic or financial abuse, as we just spoke about. On the point of economic abuse, the final property orders were made, the first set of property orders were made in May 2022, and they required the father who was living in the former matrimonial home to facilitate the sale of the property at the earliest possible time and to keep the property in good condition pending the sale. He did not. He delayed the sale by about 21 months. He carried out works that actually decreased the value of the home, including pulling out a spiral staircase, removing doors and taking out parts of the second kitchen, saying he was simply addressing non-compliance issues.
Oh my goodness.
Yes.
I was going to ask how someone decreases the value so significantly.
Yeah.
But that's how you do it.
Yeah. Well, the court inferred he was actually trying to buy the home cheaply for himself. He had actually engaged a buyer's agent to do that for him. Then after settlement, he refused to release the sale proceeds, so that meant the wife could then not discharge her litigation loan that she had. And ultimately, in that time that she wasn't able to pay that off, interest of about $219,000 accrued on that loan.
Wow.
Yeah, crazy.
That's the interest alone.
The interest alone.
Yeah.
So the court found that this was economic abuse, under Section 4AB2G and the new Section 4AB2 capital A. So that was denying the mother her financial autonomy, forcibly controlling her assets and forcing her to take on additional liability. The coercive and controlling conduct ran sort of parallel to the economic abuse. A few of the standout examples of this husband's behaviour. He resisted using the application Our Family Wizard from a period of about 2021 until 2024. When he did then eventually sort of concede using it, his agreement was made conditional upon the mother responding to things that he wanted her to respond to. But in doing so, he also went on to blame her for the entirety of their communication issues, and he continued to characterise her behaviour as harassment. He also filed multiple contravention applications, all of which were unsuccessful. The mother had to appear in person on at least 9 occasions because she couldn't afford legal representation. The court found that this was a weaponisation of litigation. There was also a concert that coincided with one of the birthdays of the children that the child wanted to attend. The mother had bought tickets and arranged accommodation. When she came to collect the child, the father called the police, and that resulted in the child being interviewed. The father had claimed during the final hearing that the child did not want to go to the concert, but the court found that that was not the case and characterised this behaviour as a weaponisation of the police. I mean, pretty serious behaviour.
Yeah.
Not the only time he did something like that. On a separate occasion, the mother had politely requested to take the other child to a dance concert. The father engaged in 13 days of communication warfare, manipulating the mother, trying to extract a concession regarding the summer holidays. His honour found that this conduct was designed to control the mother's behaviour by attrition and demonstrated a complete inability of the father to participate in child-focused co-parenting. He also repeatedly copied the mother's solicitors who only acted in relation to financial matters into the parenting matters or into correspondence about parenting matters, despite explicit and repeated requests not to do so. So on this point, Altobelli J found that this was conduct that was sought to coerce the mother by humiliating and embarrassing her in front of her lawyers and by isolating her from support. Finally, he also set up an email address mimicking the trademark of the mother's lawyers, and he used it for years. Henderson J described the conduct as scandalous during the course of the proceedings, and yet he continued to do it. So there are a few key takeaways from this matter. Parental conflict is not by itself family violence. I think that's a really important distinction. Two parents can be in genuine conflict without one being the perpetrator. But family violence is structurally different. That involves the exercise of power by one person over the other. And Section 4AB is wide and not to be read down. Second, coercers and controls are different but related topics. So Altobelli J endorsed the comments of Bennett J in Carter and Wilson and said that it's an error to lump them together in a single label because that risks excluding conduct which is one but not the other. And importantly, intention is not required. A perpetrator may be oblivious or even believe they're acting protectively when they're actually engaging in family violence. And I think most importantly for us as solicitors is the framing point. Altobelli in that case found that the allegations had been pleaded with real particularity. Every piece of conduct was set out with specifics, dates, communications, who said what. That's the important thing when you're running these cases, to make sure that the behaviour is properly framed as family violence.
Yeah, which would then help the court to be able to make decisions.
Yeah.
And in this case, because it went over such a long period of time, there was probably a lot of examples that could be provided.
Yeah. Ultimately, the mother was successful in her application. She was permitted to relocate, and so the children were living primarily with her and spending time with the father each alternate weekend. I think importantly, this case is the new benchmark for how a first instance judge is expected to apply the post-2024 family violence framework.
Thank you, Dina. That's really interesting and obviously a very severe case, but it does give some very good examples that lawyers can take away to be able to help understand the definition of family violence in other matters. We've loved being in your ears this week. Don't forget to like, subscribe and share this episode. If you have any questions or feedback, please reach out to us by email, or you can also reach us on YouTube, Instagram or TikTok. Stay tuned for next week's episode. New episode drops every Monday.